Hello and welcome. Today we are going to discuss about Habeas Corpus. In our past video, we have tried to adhere to the practical end of the law, and we stayed clear of theoretical aspects. And this video too, we will try to do that. Habeas corpus is a writ, and the very nature of being a writ, it can be invoked only in a constitutional court. There are various reasons for which this particular writ is invoked. For example, a detention by a public authority, an alleged detention by a private person, and even in cases of child custody, where this writ jurisdiction is invoked. But all these reasons must have one common issue. A issue which is a sine qua non, which is a prerequisite to make this writ maintainable, which is there must be a detention, and that detention should be unlawful. And every detention is unlawful prima facie, and that prima facie presumption is refuted by a legal sanctity, by order of which has a legal sanctity. So this writ can be invoked in a case where detention is made and that detention devoid of any legal sanctity. Police certainly has power to make an arrest. The famous line is, existence of power is one thing, but exercise of the power is different thing. But the police cannot arbitrarily make an arrest. They cannot make an arrest based on their whims and fancies in a capricious manner. That power can be exercised subject to satisfaction of certain conditions. Failure to meet the satisfaction of those conditions will make the detention unlawful. So this is what habeas corpus is about. So an arrest is made, and the Constitution Article 22 mandates that grounds of arrest should be made to the arrested person, the arrestee, and he should be produced before a magistrate not later than 24 hours. And if these conditions are not met, then the safeguard provided within the Constitution is violated. So that per se will make the arrest unlawful. And the beauty of our Constitution is that most intriguing part of the Constitution is that, ironically, Article 21 talks about liberty, but the very next article provides for preventive detention. Preventive detention inheres quality which is of draconian in nature, which is arbitrary, which is incompatible to democratic values, antithetical to the democratic value. Because unlike the punitive detention, where a person is detained for some offense he has committed, preventive detention, where the law itself says that he hasn't committed any offense, but he is anticipated to commit some offense. So in order to intercept him from committing such offense, is being detained preventively. It has three poles. One, a person is being detained for no fault of his. Two, who decides that whether he should be detained or not preventively is not an authority who has to answer to the public, not by any person who is elected by a public. Three, the decision of that authority, the decision which he subjectively gets satisfied that person A is to be detained preventively, is not subject to judicial review. Whereas a detaining authority states that I am subjectively satisfied based on this material that he is menace to the public disorder or security of the state. So it is in the interest of the public that he should be detained preventively, And that subjective satisfaction is not justiciable. But the court can't question that subjective satisfaction. Court can't substitute its satisfaction to the satisfaction of the detaining authority. So as I said, it has three poles. So why is such a Decorrian a law which can arise only out of a country which is ruled by dictatorship, which is certainly incompatible with any democratic country? Why such law exists? Of course, we are not going to get into the wisdom of the constitution makers. Having provided for a law of this nature, we have to assume that it is for some greater good. It's a necessary evil. So, we are not, as I said, we are not going to get into the wisdom of the law. Since the constitution provides for this, we have no option except to accept it as a law. In fact, the writ too arises from the constitution, and this preventive detention is sort of whittled down the power of writ of habeas corpus. But if a person is being detained for having committed no crime at all, then obviously the habeas corpus should be applicable there. But the preventive detention provides a legal immunity to the legal sanctity to the detention, so that whittles down the habeas corpus. That neuters the habeas corpus here. And preventive detention has, as no nexus with habeas corpus in general, but practically there is an inextricable link between those two. The reason is, a person who got arrested or got detained for a law under preventive detention, he has no option. He can't question the validity of the law in the court. He can't dispute the law, because the law, the arrest made through a law which provides for preventive detention is not subject to judicial review. Even the constitutional safeguard provides that he has right to make a representation to the advisory board, detaining authority, and the advisory board too has to consider it. And that too is not appealable. The advisory board gives a recommendation that it's good that he is being detained, and his detention can be extended beyond 90 days, and that decision cannot be taken to the court. So the only legal remedy that he can have through court is habeas corpus, where on one hand it is lawful. Preventive detention, as evil as it is, since the constitution itself provides immunity to that, it is lawful, and the habeas corpus can be invoked only in cases where there is unlawful detention. But practically, as I said, there is an inextricable nexus between both those two, preventive detention and habeas corpus. And most of the cases where the preventive detention orders are being quashed, not by the advice of the advisory board, the recommendation of the advisory board, but by way of habeas corpus. So how can habeas corpus be invoked and quash a preventive detention order when a preventive detention is not just lawful, but it has a constitution mandate? It has the constitution protection. That's a very moot question here. And that's what we are going to discuss here in following videos. Thank you so much.